would notice that here I got email like, I think you missed a semicolon on the program. It's like, we're volunteers, deal with it.
We're now live streaming.
No. Chris, are you there? Chris is our head of IT. I'll tell you what, if you want to turn off your cameras and microphones now,
Sure.
and I'm going to invite Chris to put up the title card then. Good afternoon, everyone. I'm Anthony Navaneelan from Legal Aid Ontario's Refugee Law Office, and along with Judy Michaeli, I'm one of the co-chairs of the 2022 Immigration, Refugee, and Citizenship Law Moot. On behalf of the entire organizing committee, I'd like to welcome you to the final round of this year's moot. I will let the clerk of the court introduce the mooters, but I wanted to take a moment to introduce the final round judges before that. Serving today as the president of the final round panel is Justice Mary Gleeson. Justice Gleeson was appointed a judge of the federal court in 2011. She was also one of the first judges I ever argued a judicial review in front of. I don't know if you remember. You granted it, thank you. She was elevated as a judge of the Federal Court of Appeal in 2015, where she continues to serve today. Prior to her appointment, Justice Gleeson was a senior partner with Norton Rose LLP, and she practiced labor and employment law in Ottawa with that firm for 26 years. Our next judge today is Justice John Evans. Justice Evans was appointed a judge of the federal court in 1998. He was elevated to a judge of the Federal Court of Appeal in 1999, where he served until his retirement in 2013. During his time with the court, Justice Evans authored some of the leading appellate decisions in immigration and refugee law, and he now serves as public law counsel at Goldblatt Partners. Lastly, we're joined by Justice John Norris. Justice John Norris was appointed to the federal court in 2018, where he continues to serve today. Prior to his appointment, he maintained a trial and appellate practice in areas of criminal, constitutional, and national security law. He was also a member of the roster of special advocates for security certificate proceedings under the Immigration and Refugee Protection Act from 2008 to 2018. Justice Norris currently chairs the federal court's bench and bar committee on immigration and refugee law. Now, missing from that bio is he also used to be an adjunct professor at U of T Law, including for myself. You will have noticed in your program that we had also scheduled to be joined by Rima Jamu Imse to join us as a final round judge this afternoon. But as the saying goes, we live in interesting times, and none more so than someone who serves as the UN Refugee Agency's representative in Canada. So we regret that Rima, due to the ongoing crisis in Ukraine, is unable to join us for the final round, but she will be here to join us for the closing ceremonies. So with that, I wish all the mooters best of luck, and I turn it over to the clerk of the court.
Welcome to the final round of the 2022 Immigration, Refugee, and Citizenship Law Moot, where Appellant Group 40A will be appearing against Respondent Group 40R. Before we begin, I would ask that the appellants and the respondents turn on their cameras and briefly introduce themselves so we can confirm that the judges can hear you.
Hello, my name is Kyla Ronneberg, and I'm the first appellant. I will also be speaking for 20 minutes, and my co-counsel, Thomas Feth, will be speaking for the remaining 25.
Yes, good afternoon. I'm Thomas Feth, and as my co-counsel just mentioned, I'll be speaking for approximately 25 minutes as the second appellant mooter.
Good afternoon. My name is Elias Jimenez Gonzalez with the respondents, and we'll be splitting our time equally at 22.5 minutes each.
I'm sorry, I didn't catch your name, and your name hasn't come up. Sorry, could you repeat your name?
Yeah, sorry about that. We're just dealing with audio issues to make sure we're in sync. Yeah, it's Elias Jimenez Gonzalez. So Jimenez Gonzalez is my last name. In Latin America, we have a tradition of keeping both our paternal and maternal last names. So we keep both. I've kept both here as well.
Okay, thank you very much.
And my name is Brianna Frape, and I am the other respondent. And as my colleague said, we'll be splitting the time evenly.
Having confirmed that those in attendance can see and hear the mooters, I declare the special sitting of the Crown Court of Canada is now open. I would like to recognize that we are attending this event virtually across Canada and invite you to acknowledge the traditional land on which you are situated. I am located today in Toronto on the traditional territories of the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. Since the mooters have confirmed the order in which they are appearing, once the judges are ready to proceed, they can invite the appellants to begin their submissions.
Good afternoon, Council. I would turn it over to the appellants. Ms. Ronenberg, are you commencing the submissions?
Yes, thank you. And good afternoon, Justice Gleason, Justice Evans, Justice Norris. My name is Kyla Ronneberg, and I, along with my co-counsel Thomas Feth, represent the appellates, Halit and Helena Cadere. My friends, Elias Jimenez Gonzalez and Brianna Frape, represent the respondent, the Minister of Public Safety and Emergency Preparedness. This case raises the issue of what length of administrative delay in immigration matters is unfair and unreasonable. Over the years, administrative delay has grown into an unwieldy issue within our justice system. When considering immigration and refugee law, the stakes for the individual involved are extremely high. As stated by Justice Iacobucci, I cannot imagine an interest more fundamental to full membership in Canadian society than Canadian citizenship. This case exemplifies the frustrations and concerns of delay in the immigration law context. The minister's 12-year delay in bringing an application to vacate has had a significant impact on the Cadere siblings, who themselves played no role in this delay. And this is why we are asking for the decision of the RPD board member to be restored. Today, we will be covering 3 main points. First, that the minister's 12-year delay constitutes a breach of procedural fairness under the first branch of the Blencoe test. Second, that the delay constitutes an abusive process based on personal prejudice under the second branch of the Blencoe test. And our third and final point is that a stay of proceedings should be imposed. I will be addressing the first issue of procedural fairness, and then I will introduce the second issue, the second branch of the Blencoe test, by considering inordinate delay, while my co-counsel will cover serious personal prejudice and conclude the second branch of the Blencoe test. Then he will cover the third issue, requesting a stay of proceedings. For the issue of procedural fairness, I will cover 2 main points. First, that the lack of a record prevents the proper application of the Immigration and Refugee Protection Act, Section 109, Sub 2. And second, that the minister's delay in informing the Caderes of the investigation defeated their ability to recreate the original hearing. In Blencoe in British Columbia, the
Councillor, may I ask a question at this point? Is it apparent from the record when the record of the IRB was lost?
Thank you, Justice Evans. It's not quite clear when exactly that was lost. Based on the facts, we have correspondence between the Cadere siblings and the RPD board, where they've informed that as of their request following their 2017, that information was no longer available. But based on the facts, we don't have the exact date.
So we can't necessarily attribute the loss of the record to the delay. Is that right? We just don't know when the record was lost.
Well, there's other elements too, where we also have documents from counsel, and we also have witnesses that have died or become unavailable in addition. And we do know that Alba Cadere, for example, the mother, only died in 2006. And so that was between the time of 2005, when everything was available, and 2017, when the application was brought.
Thank you.
So in Blencoe and British Columbia, the Supreme Court of Canada identified that administrative delay can lead to an abusive process in 2 ways. 1, by prejudicing the right to a fair trial, or 2, by prejudicing the integrity of the justice system. So we will start by considering the first branch, which is where delay impairs a party's ability to answer the complaint against him or her because, for example, memories have faded, essential witnesses have died or have become unavailable, or evidence has been lost. So if you turn to paragraph 32 of the appellate's factum, we begin our argument looking at section 109 sub 2 of the IRPA, which states that the Refugee Protection Division may reject the application to vacate if it is satisfied that other sufficient evidence considered at the time of the first determination justified refugee protection. This suggests that the legislature intended to sustain refugee protection if, after eliminating the material misrepresentation, the refugee protection was still justified. However, as held by the Federal Court of Appeal in Kumaraswamy and Canada, the words "other sufficient evidence considered at the time" includes only the documents from the original claim. In this case, most of these documents are lost. The RPD does not have the documents from the original claim to be able to determine if evidence presented at the original hearing would have granted the Cadres refugee protection. And producing additional evidence would be an improper attempt to prove their claim de novo.
Ms. Ronenberg, I wonder if I could interrupt you at this point. The RPD member appears to have made a very favorable factual finding for the appellants, finding that there was no basis to determine whether there's any realistic chance to have found any of this missing evidence. On what was that finding based? Because as I understand, one of the concerns raised by the federal court, it was the lack of any real effort by the appellants to try to track evidence down, if not in its original form, at least in a somewhat reconstituted form.
So when we're looking at the efforts placed by the Cadres, we don't actually know what was, sorry, let me rephrase. So when we're looking at these evidence, at these letters, because if we look at the decision, we can see that Rezmi Kadre spoke about many things, and his evidence was supported by letters and other documents. But we don't know what these letters contained. We don't have summaries of these letters. We don't know their contents. We don't know who wrote them. We don't even know how many there were. And so if we invite the Cadres to go and gather additional evidence, letters that we don't know were initially there. Additionally, we don't know that whether or not the CNR provided any documents initially. And so I do note that the federal court asserts that the Cadres should have contacted them, but because we don't know what was in that original package, and we don't have Alba Kadre or Rezmi Kadre, any witnesses from that time who can confirm, by inviting them to recreate, and because they don't know what was in the initial one, it's essentially create a new package. This really seems to be inviting this de novo hearing, which is contrary to legislative intention.
Is it clear from the RPD member's reasons whether he relied upon submissions or evidence other than related to 1998?
In the RPD's decision, he mentions that Rezmi Kadre spoke at length about many things. Yes, there was, of course, the material misrepresentation regarding the events in 1998, but Rezmi Kadre also provided detailed testimony about the blood feud between the Tahoe and Kadre families. He spoke of the escalating violence and bloodshed in 1997, and he spoke about the deaths of his family members. And so it is possible that these are the items that these supporting letters spoke to. And it is possible that this is what the original board member found compelling.
And when did Hallett and Helena realize that there was a problem? It really wasn't until the application to vacate was instituted, is that right?
Yes, they hadn't even been aware that they were refugees initially. They knew that they were permanent residents, but they hadn't been aware before the application to vacate that the refugee status was how they'd acquired permanent residency.
So they had no reason to be looking for any evidence or documents before 2017?
No, yeah, they weren't aware, and they weren't aware of a material misrepresentation. They weren't even aware that they had been refugees.
Sorry, I'm on mute. In terms of that evidence that was lost, where did the burden lie to establish that it mattered? Was that with your clients in terms of the test under section 109 sub 2 of IRPA?
To establish that it matters, yes, it's largely with the cadres.
And if it was their burden, how have they discharged that burden if they didn't do anything to attempt to locate the evidence?
Well, they have made some attempts. They have the correspondence with the RPD where they've discovered that the evidence wasn't available. They've also talked to counsel who represented them at the time, and both of those documents have been lost due to the passage of time.
But they didn't do anything further and didn't question the tribunal in Albania. Wasn't it incumbent on them to do that?
Well, like, since we don't know that the CNR provided any documents initially, we do run into this risk of creating really a new application. And the issue here is, because the cadres are innocent, we maybe feel that we want to stretch these rules for them. But a lot of the people that are applicants under section 109 sub 2 are the original representatives who did make the material misrepresentation themselves. And so when that comes around, they want to now fill in that gap with additional information. And so that's really the legislative purpose behind section 109 sub 2. It's to ensure that we give refugee protection where it's deserved and don't strip it from unnecessarily. But it's also not to advantage people that have made a previous misrepresentation by allowing them a second attempt.
What about attempts to try and find their father? He surely was the most key witness. And wasn't it incumbent on your clients to put forward evidence of their failed attempts to find the father?
The challenge with finding Resmi Kadare is that he was last seen by his own children in 2001. And we know that in 1999, they were 5 and 7 years old. So he was last seen by them when they were children. And we also know that the RPD board member has attempted to deliver the vacation package to Resmi Kadare, but they haven't actually found him either. And so when we're comparing the relative resources of the government of Canada and to immigrants, it seems unfair to expect them to succeed in finding a man that they haven't seen since childhood when the government of Canada, with all of its resources, hasn't. Turning to my second point, the minister's delay in informing the cadres of the investigation defeated their ability to recreate the original hearing. And so our argument on this begins at paragraph 35, where we say that in 2005, we note the minister held all the evidence that was eventually tendered to support the application to vacate the Kadare family. In 2005, the minister had received confirmation from the Norwegian consulate officials, which confirmed that the Kadares were in Norway from January to April 1998. But having gathered all this information, the minister waited for 12 years. When we look at the concerns raised by the first branch of the Blencoe test, these concerns that memories have faded, that essential witnesses have died or are now unavailable, and that evidence has been lost. We see all these concerns coming to life in this case. As I mentioned, in 2017, the minister brought the application to vacate, but the year prior, in 2016, Alba Kadre had died. These are the witnesses that have died and become unavailable. The RPD board no longer has the complete record of the Kadre files, and previous councils destroyed their files. This is the lost evidence. The federal court suggested that the Kadres needed to conclusively identify specific issues where they required these original transcripts. However, as stated by Justice Laforêt in Carey in Ontario, this requires the Kadres then to demonstrate how documents which they had never seen would be of assistance. They were children at the time. They were not present in the hearing room. They did not participate in any oral testimony. And so the contents of that lost record are a matter of speculation. No application for relief could ever succeed if the applicant was required to show that their defense was prejudiced based on material unavailable to them. Moving to the second branch of the Blencoe test, a delay in proceedings can be abusive even when there is no hearing unfairness. In these cases, the delay must be clearly unacceptable and have directly caused a significant prejudice that amounts to an abusive process. It must be a delay that would, in the circumstances of the case, bring the system into disrepute. So turning to paragraph 47 of the appellant's factum, we begin by considering an abusive process, which requires unacceptable delay that results in significant personal prejudice, and the resulting damage to the integrity of the justice system is such that the community's sense of fairness would be offended by the delay. So we'll start with the first element, unacceptable delay. In the majority decision in Blencoe states that the determination of whether a delay is inordinate is not based on the length of delay alone, but on contextual factors, the nature of the case and its complexity, the facts and issues, the purpose and nature of the proceedings, whether the respondent contributed to the delay or waived the delay, and other circumstances of the case. And so this is a non-closed list that can be challenging to wrangle. And when we look at the federal court decision, we see that there was a struggle in attempting to wrangle this. And some of the factors, such as whether the respondent contributed to the delay or waived the delay, weren't considered. The Kadres were not even aware that they had come to Canada as refugees. And so they were not aware of the investigation against them until it was brought in 2017. So the Kadres really had no elements in contributing or to waiving the delay. Justice LaBelle's dissent in part provides some helpful structure trying to manage this non-exhaustive list, where he identifies three factors to balance. One is the length of the delay, the time taken compared to the inherent time requirements. The second is the causes of the delay, beyond the inherent time requirements of the matter. And the third point is the impact of the delay. So looking at this list, we can see how these elements fit underneath each other. When we consider length of the delay, we can see how the nature of the case and its complexity fits within that assessment of the inherent time requirements of the investigation. Causes, I've already mentioned that element of whether the Kadres had contributed to the delay. But in this case, the 12-year delay was not caused by the Kadres. It was entirely under the supervision of the minister. While the IRPA does not have specific time limits to make vacation applications, the federal court did not consider these causes. And the minister failed to provide any reasons for this delay, even now. And as stated by the Saskatchewan Court of Appeal in McBain and Investment Dealers Association of Canada, the lack of any real explanation weighs in favor of finding an unreasonable delay. A reasonable delay surely requires reasons. And being mindful of my time, unless there are any further questions, that will conclude my submissions.
Thank you very much. I'll turn it over now to your colleague to complete the balance of the submissions on behalf of the appellant, or the appellants.
Thank you, Justice Gleeson. Good afternoon, Justice Gleeson, Justice Evans, and Justice Norris. I'll be speaking to the issue of personal prejudice and abusive process under the second branch of the Blanco test, and that begins at paragraph 69 of the appellant's factum. Vacation proceedings are not like any ordinary civil or administrative procedure. What's at stake here is not a financial liability or the issuance of some permit. What's at stake here is membership and a settled life in Canadian society. And the abusive process doctrine is a safeguard. The doctrine protects the public's interest in a fair and just process, and also in the proper administration of justice. And as we know from the case authorities, a stay of proceedings can be granted to prevent the continuation of a wrong. And as my colleague introduced, the Blanco framework sets out that in situations where excessive delay has caused other forms of prejudice, so those types of prejudice unrelated to hearing fairness, that prejudice can also amount to an abusive process. But it must be significant enough to the extent that it would bring the system itself into disrepute.
Mr. Fev, can I just ask you a question at this stage? What personal prejudice do you say that the appellants have suffered up to this point?
Well, there's two primary forms that I'll discuss. So the first is the practical prejudicial impact of the delay. So the Cadres were led to believe they could establish themselves in Canada, and now they risk losing that life that they've established here. And there's also a psychological harm, and I'll certainly get into that with my submissions. And
sorry, if I could interrupt and just build on my colleague's question. One of the concerns about delay that is articulated in the case law is the idea of a proceeding hanging over one's head for an unduly lengthy period of time. But that doesn't seem to be the case here, is it?
So concerning psychological harm, there was something hanging over the Cadre siblings' head. Now, in 2006, there was citizenship applications that were submitted by the Cadres. Now, despite multiple inquiries, for over a decade, they never received an explanation as to why there was no decision on those citizenship applications. So this was weighing and hanging over the head of the Cadres, and it certainly made them question their status in Canada. And we know from the RPD board members' findings that the delay had caused them significant stress and anguish because they felt uncertainty about their futures in Canada. And the RPD board member felt that in part that testimony was compelling enough to find a finding of psychological harm, similar to the case of Canada and Perec, in which the testimony alone was compelling enough for the judge to find that there was psychological harm that was suffered because of the delay.
So you say the prejudice was that they didn't understand why they had not heard anything about their citizenship application?
Well, it's a combination. So there's that piece, so the psychological harm piece, but there's also the practical prejudicial impacts. So I'll first discuss how the delay has had that prejudicial impact on the Cadres, and then I'll explain in more detail how this proceeding has effectively tainted the refugee determination system. And then to conclude my submissions, I'll discuss more specifically the public interest considerations and access to justice principles and how they warrant a stay of these proceedings. So concerning the primary prejudice here, since 2005, the Cadres have grown up in Canada. They've completed their post-secondary studies here. They've started their careers. They've purchased property, and they've entered into relationships with Canadian citizens. So if there was no unreasonable delay in these proceedings, the Cadres likely never would have invested such a significant part of their lives on these endeavors in Canada.
Well, but hasn't that been a benefit to them, that they've had the benefit of living in Canada, having an education, building careers, forming relationships?
Well, it's certainly benefits because they want to stay here. There's no doubt about that. They've made it clear to in their application that they do want to remain in Canada. So of course there is benefits, but if that is coupled with the loss of that foundation that they've created, that's a significant prejudice. So if they've been led to believe that they could establish their lives in Canada and they chose to do so instead of doing so elsewhere, whether that be Albania or some other country, so they've effectively been led to believe they could do it here, but then 12 plus years later are told that's not the case, and now they have to leave. It's in our view that's a significant prejudice, what the minister's delay.
So you're saying that the prejudice is really a future prejudice. It's not that they are prejudiced to date, but that they face removal.
Well, it's almost a certainty. So perhaps there is a small difference between harm that has occurred versus harm that we know will occur, but that's certainly a significant prejudice that is going to happen. And we know that part of the purpose of a stay of proceedings is that it's a prospective remedy. It looks to the future to see what harm needs to be stopped. And what we see here is that there is an ongoing wrong, and the consequences of these proceedings would be a significant harm to the Cadres. So it certainly would be harmful. And that's in conjunction with,
Sorry. In making that submission in terms of future harm, there's a huge assumption contained in your submission, I suggest, which is that there wouldn't be any other basis upon which your clients could remain in Canada. That, for example, they wouldn't have an H&C application considered and granted. They might not find some other pathway to permanent residence that's open to them under IRPA. Is it appropriate and to make that concession?
Justice Gleeson, in our view, there's no other reasonable options for the Cadres to pursue permanent residency in Canada. For example, if we take an H&C application, this is not a guarantee of permanent residency. Under the IRPA subsection 25 1.2 CI, the IRPA stipulates that if there's a finding of misrepresentation, the Cadres would have to wait up to a year to even make that application for an H&C exemption. And not only that, but they would likely have to face, or it's certainly possible they would need to face years of waiting for a decision on that H&C application. And so because there has been such an inordinate delay already, we have 12 years plus the 5 years since 2017, we would be asking the Cadres to wait even longer to resolve their situation after their permanent residency has been vacated. And in our view, a remedy for delay should not be more delay, and asking the Cadres to wait even longer to resolve their future here in Canada when we have the opportunity to do so now just doesn't seem appropriate.
And where would they be waiting, in Canada or Albania?
Well, in our view, it's certainly likely that removal proceedings could begin immediately after their status has been vacated. And that's part of the danger with allowing this proceeding to continue and suggesting that they simply apply for an H&C exemption, because they'll have this 1 year period where they're unable to work they're unable to exercise any of the other rights associated with permanent residency, and that could put their status or their settled life here in great jeopardy. So it's entirely possible. In fact, it's likely that they would be removed, and they couldn't even make an inland agency application. So that is certainly a significant prejudice in our view.
And is the prejudice that you say they are likely to suffer any different from the prejudice that many people who are subject to removal orders would suffer?
It is, Justice Evans, because it's a response. It's a result of the delay. So we know from the abusive process tests, a stay can be granted in exceptional cases, and there is certainly an exceptional case here. So you raise the issue of how. Sorry, Justice Evans, could you please repeat your question? I just want to make sure I'm answering it correctly.
My question was, will the prejudice that the appellants are likely to suffer any different from the prejudice that other people who are subject to deportation order removal would suffer?
Thank you for your clarification, Justice Evans. So the key difference here is the delay. So it's certainly true that for applicants in immigration matters, there can be frequently significant delays and there can be consequences to those delays. The difference here is that there's been an inordinate delay. So there is this 12 years in which the minister did nothing when they could have brought this proceeding back in 2005. And what that delay has done is that it's effectively created this prejudice. So it's not just the consequences of the proceeding, but it's that the consequences have effectively been created by that delay. And that's what the abusive process doctrine is ultimately here to remedy, where you have this inordinate delay that causes prejudice, such that the system would be brought into disrepute.
So then the implication of what you're suggesting is that anytime you had a similar or somewhat similar length of delay in an immigration case, there would of necessity be an abusive process that results in a stay of whatever ongoing proceeding that might be still under consideration.
Not necessarily, Justice Gleason. So only if it's inordinate and only if it causes a significant harm, such that the system would be brought into disrepute. And so, if there's a situation where a 10-year delay goes by, but no prejudice is created at all, then it's quite clear from the Blanco test and subsequent jurisprudence that that wouldn't rise to the level of an abusive process and it wouldn't warrant a stay. But what we see here with the Prejudice is that there was this at least a 12-year of completely inordinate, unexplained delay that has led to them thinking they could establish their lives here. And so they've, over the course of over a decade, have put their roots down, established their lives here on the assumption that they could be here and stay. And now they stand to lose all of that because the minister's delay when they could have established their lives somewhere else. So that's the key difference. It's not just the delay alone, but it's the accompanying prejudice as the result of that delay.
But that will often be the case in an immigration case where somebody's status has not been finally determined, won't it?
Not in every case. I think for abusive process, the key is that it has to be an inordinate delay. So it's not just the number of years, but it's if the proceedings themselves have actually been tainted by the delay. So as my colleague discussed, when it comes to the delay, we have 12 years of unexplained delay. I mean, these proceedings could have been brought back in 2005 and there's no explanation. And so that doesn't, as far as looking at the case law goes, it doesn't seem like that's a particularly common thing, that there would be a 12-year delay without any communication or any explanation. And so that delay in conjunction with the prejudice is an exceptional case here.
In terms of your client's situation of sort of not being able to finally settle their lives and now having to make huge life changes, wouldn't that also be the case if the misrepresentation were just discovered in 2017? So how is the delay the cause of the situation they find themselves in?
Would you mind repeating your question, Justice Gleason? My apologies.
I said, the prejudice that you're suggesting in terms of having their status altered and having to fundamentally reorient their lives, wouldn't they be in the exact same situation if the minister didn't discover the misrepresentation until 2017, and at that point initiated the vacation proceedings in front of the board, so that the prejudice that you're asserting is from being party to an application where misrepresentation was made as opposed to the delay, isn't it?
I understand your point, Justice Gleason. It's difficult for me to comment on that question in regards to this case, because I think if that's how things had occurred, then some of the other facts could have been quite significantly altered when it comes to the conduct of the mother or decisions to settle in Canada based on the information that they had. I think if there was that significant change in the facts, I just think it would change the situation too much from what it is now, in order for us to decide what would happen as a result.
Mr. Feth, I wonder if I could weigh in at this point as well. I certainly understand your colleague's argument about the prejudice to a fair hearing and the entitlement to a legal remedy for that. But when you move into the personal prejudice side, on the one hand, the appellants can make a very compelling case. This is where their lives are. This is where they've built their lives, and they're about to lose that. But what I'm struggling with is whether that entitles them to a legal remedy in the form of a stay of proceedings, as opposed to relief from the misfortune that they're facing under an H&C application. And this was one of the concerns of the federal court judge, where he seemed to think that it was that the RPD had sort of force fit H&C considerations into the legal remedy where they didn't belong. What do you say about that?
Justice Norris, my response to that is that the abusive process analysis at its heart is a balancing of the public interest. And so when we're balancing here the interests that are important in weighing whether to grant a stay and whether to find an abusive process or not, we do have to take a flexible approach and weigh all the different factors to see if it's appropriate here. I would note that the Supreme Court has said in subsequent cases since Blanco has held, including in the Ben and Moulton Consulting judgment, that the abusive process doctrine is a flexible one, and it's unencumbered by specific requirements. So those were the words of Justice LaBelle in the Ben judgment. And so what that gives the court is the flexibility to consider these factors, these public interest considerations, and to weigh whether the impact on the cadres is significant enough that we can grant a stay, even when it means we don't proceed with the hearing and we don't have a proceeding based on its merits. And ultimately, it's a question of how tainted is this proceeding? Is the proceeding tainted to an extent that it should stop now, or should we allow it to proceed based on, even though there's been this prejudice that has occurred? And it is our submission that there was significant prejudice here. There was an incredible impact on the cadres, and that has tainted this proceeding to such an extent that it should stop.
And how significant a factor in that weighing, and as you rightly point out, this flexible legal test, how significant is the fact that if a stay is granted, it will leave the appellants holding a legal status that they are not entitled to?
Justice Norris, I'll note that there is precedent for this notion that a stay of proceedings might be granted, and it may leave an applicant with a status they may not have initially been entitled to. So in the Canada and Perec case, it was a situation where the applicants, or the defendants rather, had made misrepresentations in their citizenship applications. So they had actually lied about previous a criminal record and criminal convictions, and that's how they obtained citizenship in Canada. And over the course of 5 years, there were significant inordinate delays that the judge found in Canada and Quebec. There were significant prejudicial impacts, including the denial of access to travel documents, passport documents, the suspension of an H&C application. So there was some significant prejudice. And even though they had lied and effectively weren't entitled to Canadian citizenship, and there was the existence of these revocation proceedings, the judge in that case still held that the proceeding was tainted to such an extent, it had really harmed the lives of the defendants, that it was in the interest of justice to just end the proceeding here instead of having a final decision on the merits. And so the courts do have the flexibility, and they do have the capability to step in and do that. And it's in our view, they should certainly do that here with the Prejudice.
Mr. Feather, are you conceding that the appellants are not entitled to refugee status?
Well, there was certainly a misrepresentation. There's no doubt about that. Yeah.
But isn't the issue that we don't know, because we don't know whether there was other evidence upon which the RPD member could have come to a decision?
Well, Justice Evans, of course, there is the existence of 1092 of IRPA. So there is the potential for them to, there is a pathway to maintaining that refugee status. So it's not 100% certain that they would lose it. But, there was that misrepresentation. So that has been conceded.
Oh, I understand that.
Okay.
Have you come across any case, can you refer the court to any case in which the prejudice you need to establish for the purpose of abusive process is a prejudice in the future? Because that you're really relying upon the consequences of their removal, not prejudice that they had suffered in the previous 12 years.
Justice,
because Blanco itself was certainly a case in which the prejudice had occurred beforehand, reputational damage, stress of having these proceedings hanging over them. And I think you said, well, that really isn't the case here. It's really the removal after 12 years.
Yes, Justice Evans, thank you. There's no perfectly analogous case, and I think that speaks to the nature of the abusive process doctrine, and also the nature of many of these immigration and refugee proceedings, where they are so fact specific. It is difficult sometimes to compare fact scenarios and situations and to say, well, here's a like for like harm, or here's a like for like prejudice. Now, in my reading of the cases, there's no perfect analogy for the prejudice that the Prejudice have suffered. But if we take the difference between harm that has occurred versus harm that is almost certain to occur, in our view, that does satisfy the requirement of a direct causal relationship between the prejudice and the delay.
Thank you.
And I'm just mindful of my time. So I just want to briefly conclude by asking this court for a stay of proceedings, in part because the Supreme Court has signaled a shift toward combating delay, excessive delay in our justice system. And when we look at the recent Supreme Court jurisprudence, including Hraniak and Malden, Jordan judgment, and also Vavilov, which suggests that access to justice principles can allow a court to grant remedies based on access to justice principles. There is that shifting Supreme Court jurisprudence to combating delay in our justice system. And I would also note that in the realm of immigration and refugee law, as we've discussed a little bit at length, some of these delays can have extraordinary and detrimental effects on people's lives. Refugee claimants often have to wait years for a decision on their refugee protection. Applicants have to wait for permission to work. Residents must wait to be reunited with their families. And so in cases of inordinate delay, these waiting periods and these clouds that hang over people can become so much worse, especially in the case of the Prejudice. And we know from some of the jurisprudence, including from the Supreme Court in Andrews and Law Society of British Columbia, that non-citizens are seen as vulnerable. We know from Federal Court of Appeal jurisprudence that refugee claimants have been described as a vulnerable, poor, and disadvantaged group. And the Prejudice siblings are similarly vulnerable due to their lack of citizenship rights here, and their now newly found precarious state in Canada that comes with their potential loss of status. And so it's these principles aligned with the public interest in preserving the integrity of our immigration and refugee system that warrant granting a stay of proceedings in this matter. And to reiterate, we the appellants are asking that this court restore the RPD board members' imposition of the stay of proceedings, and subject to any further questions. Those are my submissions.
I don't see any further questions. Thank you very much for your submissions. I'll turn now to counsel for the respondents, please.
Thank you very much, and good afternoon, Justice Evans, Justice Gleeson, and Justice Norris. My name is Elias Jimenez Gonzalez, and I'm here today with my co-counsel, Brianna Freight. And we represent the Minister of Public Safety and Emergency Preparedness in this matter against the Plaidoiries. Now, Justices, the question that we are here to answer today is whether individuals that are in Canada on the basis of a misrepresentation should get to remain and benefit from that status just because the minister's application took too long. We submit that to make this finding would be to go against the purpose of Canada's immigration system and frustrate the government's ability to determine how it allocates resources to these administrative bodies. The government has already created a system via the temporary resident permits and humanitarian and compassionate applications, among others, that give remedies to people in the Plaidoiries situation to remain in Canada if the interest in them doing so is high enough. There are 4 issues that we submit arise from these facts. I will speak to the issues of inordinate delay and hearing fairness. My co-counsel, Brianna, Ms. Freight, will speak to the issues of personal prejudice and the appropriate remedy that should be awarded in this situation. Just before I move on to my arguments, I want to agree with my friends that the relevant jurisprudence that guides this discussion can be found in Blanco. And what the Supreme Court tells us there is that you need 2 things for a finding of abusive process on the basis of delay. First, you need to find an inordinate delay, which is a delay that is so oppressive that it taints the proceedings. But that alone will not be enough. That delay must also either prejudice the fairness of the hearing or cause personal prejudice. On the topic of inordinate delay, we have 2 submissions. First, that the time that could be characterized as a delay does not start until after the proceedings before the administrative board have commenced. So in this case, not until 2017 would the time period that's relevant for abusive process count. And second, that even if the investigation period prior to 2017 counts, that is not enough for a finding of inordinate delay on these circumstances.
As I understand it, Councillor, by 2006, the minister had discovered the critical piece of evidence that undermined the claim, namely that the appellants were in Norway during the time when the father said that he was being threatened. So the minister knew then that there had been a misrepresentation. And yet for the next 12 years, as far as we know, did nothing, did not communicate with the appellants in any way. So how can the period not start in 2006 when the minister had the critical bit of information?
Thank you for the question. So just before I turn to some of the authorities that support this point, I just want to quickly mention that yes, it is unfortunate that the minister did not start the proceeding at an earlier stage. And as many immigration practitioners know, and anybody before the courts knows, the sad reality of the immigration system is that it is quite overburdened. So there is quite a lot of applications that go through Canada's immigration system, partially because it is so generous and so open for immigrants and refugees to be able to come here and settle in our country. But because of that, the amount of volume that the system sees is quite high, and it can be quite difficult for the minister to handle all of the applications that ultimately end up at their desk.
Mr. Jimenez Gonzalez, I apologize for interrupting you, but did the minister actually lead any evidence before the RPD to explain that the delay in this case was because of the significant volume of cases that were having to be processed?
No, so that was not a submission made before the RPD. However, it is a reality of the situation. So it's something that I would like to ask for you to take judicial note of, and not something that was before the initial board.
In fact, the minister gave no explanation, isn't that correct?
Yeah, there was no explanation given for this particular delay.
And wouldn't you think that when you're dealing with something as fundamental as a individual's rights to reside in a country and obtain citizenship, that just prima facie 12 years is a very long time? And in light of that, wasn't it incumbent on your client to provide some sort of explanation?
So it is a very long time, and it is regretful that there is no explanation on the table. However, the Supreme Court tells us in blanco that we cannot make a decision on whether a delay was inordinate just on the basis of the time period or delay alone. We have to look at other factors. So that alone will not be sufficient. And perhaps now I'll bring on one of the authorities that support our position that the time period shouldn't start until 2017, just to draw some parallels. But Justices, if you're not satisfied on that point, I'm happy to move on to speak about why, when we consider all the factors, even if the investigation period counts, we should not find this to be an inordinate delay.
Your case, counsel.
Thank you. So one of these cases is Seed in Canada, which was a case where the minister brought forward a reavailment proceeding. So Mr. Seed went back to the country that he claimed protection from in Chad, and the minister had knowledge that that Mr. Seed was in Chad as early as 2006. Yet much in like our case, they took no action until much later on in 2016, despite having all of the information needed for the reavailment proceedings 10 years earlier. Like here, Mr. Seed also claimed abuse of process on the basis of delay. But the federal court there upheld the IRB's finding that they could only consider the delay that occurs once the proceedings are underway. And there are two good reasons to consider why this should be the case. So first, in cases like the Cadaris, and like Justice Norris pointed out, the Cadaris and people like Mr. C do not have the proceedings hanging above their head for a prolonged period of time. If we look at the cases where the investigation period has counted, because I do want to acknowledge that there is a parallel line of cases where, like Parek, like Fabiano, where the investigation period went towards the proceedings in the finding of abuse of process. But in those cases, the permanent residents in question were in fact part of the investigation proceedings. So they were informed from an early stage that they were subject to these proceedings. And they had the case hanging above their head for many years while the minister did nothing. And this is not like that. And the second reason why this line of cases should be upheld is because ultimately, while the delay is unfortunate, there really is not much of a difference between the 12-year delay period occurring and the minister finding the misrepresentation in 2017 in terms of the prejudice that's actually that the Qataris are actually suffering. So for those two reasons, we submit that the delay was only 30 months once the proceedings were already underway. And that would certainly not rise to the high level set out in Blanco. However, justices, if you're not satisfied on this point and you think the investigation period should count, even then we have to look at all of the factors in order to come to a decision as to whether the delay is inordinate.
Wherever we start the clock, is it not the case that the prejudice to a fair hearing is the same?
Yeah, so the case authorities on hearing fairness primarily comes from Canadian Union of Public Employees, which is a separate line of reasoning altogether from Blanco, one which is somewhat adopted in Blanco. And that really goes as to whether the administrative body was able to make a decision on the merits based on the information that they have available on it. So if they can't, then the hearing was unfair and the duty of procedural fairness was breached. However, right now we're just looking at inordinate delay. So those concerns don't arise until a little bit later on in the process.
But even if we were to accept your argument that the clock didn't start to run until the matter was filed with the RPD, which, speaking for myself, I don't find particularly persuasive, but in any event, even if we were to accept that, are there not still serious concerns about the fairness of the hearing because of the passage of time and the loss of evidence?
Certainly there are, and I will address those. In fact, I can turn to those concerns right now. Sorry. Yeah, so ultimately, the starting point here is whether if there's a statutory right to a record, then certainly the Qataris would be entitled to the full record before them to be able to have a claim for a fair hearing. In this case, there is no statutory right to a record in the IRPA. So we just have to assess whether the RPD could make a full determination on the merits just based on the information that it had available. And we submit that they can. So there's a line of authorities that essentially goes to the conclusion that whenever you have an original set of facts that is later on frustrated by the real events that occurred, that gives the RPD the ability to make a decision, and that's sufficient to dispose of the application. And the reason for...
But on procedural fairness, isn't the question that, isn't this really the issue, that the appellants had the right to make representations on whether there was other evidence upon which the RPD member could have come to the same conclusion. But they've been prevented from being able to exercise that right because the record has been lost or destroyed and witnesses can't be found. Or those that could be found, either memories are unlikely to be reliable. So how can they possibly make their case when, as a result of the delay, the material has been lost or witnesses not available or won't remember?
Certainly. So on this point, we submit that we start with a rebuttable presumption that there's a lack of credibility in the initial proceedings. And we do this on the basis of authorities like Omar in Canada. So just for some context, that was a case where Ms. Omar had gotten refugee status on the basis of difficulties that she had encountered while in Somalia, when in reality, she was in the United States for the relevant period. And the court in that instance found that that was enough for them to make a full decision on the merits. Now here we have the additional complication, as you rightly point out, that there is section 109 sub 2 that gives the Qataris the opportunity to make submissions that there is some evidence that was before the original board, not impacted by the misrepresentation, that could nonetheless lead the board to grant refugee status. However, that's a case similar to HILU and Canada, which also included, let me just make sure I'm not mixing up my authorities here. Yeah, so that case also included, if I remember correctly, a Section 109 sub 2 defense. And generally speaking, what occurs is that a finding of a misrepresentation puts the general credibility of all of the documents into disrepute. Now, this is a rebutable presumption. We recognize that we can't go as far as to claim that a misrepresentation destroys all the evidence before the initial board, because that would frustrate the purpose of Section 109 sub 2. But ultimately, the onus is on the Qataris to show that there are some documents that support their case. And they have had...
Do we know that there were, because doesn't the RPD member refer to documents supporting Mr. Qatari's testimony?
Yeah, so the RPD primarily relied on Mr. Qatari's testimony. They specifically found that his testimony was without any notable internal inconsistencies, and also consistent with the allegations as laid out in his personal information form and attached narratives, and the supporting letters. And one of those supporting letters, and the one that we would like to focus on, is from the CNR. Now, as my friends have rightly pointed out, we do not know the contents of that letter or who wrote it. But nonetheless, the CNR confirming their involvement in a Qatari-Tahoe blood feud would show some credibility to the document that was before the initial board. And this is not risking a hearing de novo, like my friends have suggested, because it would just prove that the evidence that was before the original board was credible. So there are still some documents that are, other than Mr. Qatari's testimony, which we can no longer rely on, given this misrepresentation, might be able to prove a Section 109 sub 2 defense. But the onus is on the Qataris to provide those documents, and they have not met that onus. Sorry, Justice Gleeson,
Sorry.
on mute.
Yeah, in terms of my colleague's question, returning to it, the point isn't that the Qataris would win on the 109-2 argument or be successful, but they've been deprived of the ability of making it because the essential building blocks for them to argue their case have disappeared through no fault of their own over the passage of time.
So there are indeed difficulties, as my friends have pointed out, and as the court is pointing out, with putting forward the Section 109 sub 2 defense. Nothing can bring back the Qatari's parents, and the record has unfortunately been destroyed, and the whole hearing took place before the implementation of the global case management system, which might have otherwise saved some of those documents. However, the Qataris are still in a position where they could reach out at the very least to the CNR and try to obtain some of those documents that could help them in a Section 109 sub 2 defense. So it's not like it's impossible for them to make that case. They still have an ability to try and find those documents, but have not met their burden.
But how realistic is that? 12 years after they learn about this for the first time as young women, how is that realistic?
We think it's very realistic.
They had no idea what the documents were. They don't know what they're looking for.
We think it's very realistic to, at the very least, to reach out to the CNR just to confirm their involvement in the matter. We do not need to know necessarily the content of the letters if we know that the Qatari and Tahoe blood feud was a real thing that the CNR looked at. That alone would show some credence to some of the documents before the initial board. And that would be very persuasive in bringing forward the Section 109 sub 2 defense.
So you're suggesting the CNR's record keeping is better than that of the IRB's?
I'm not suggesting that the original letter may still be present, but I am suggesting that their confirmation that they were involved in that matter at all, which is a much lower burden, would be beneficial to their case. And just at this point, perhaps it would be helpful if I briefly discuss one of the clear cases where an abusive process allegation is fully made out. And to that, I turn to a case that my friends also mentioned in their factum, Fabiano and Canada. So Mr. Fabiano was convicted on some minor criminal charges, but was also accused of being a member of the Hells Angels. And the minister had knowledge of all of the facts and brought forward their application in the mid-2000s. Now, the reason why the court found delay in that case was for two things. First, like I argued earlier, Mr. Fabiano was involved in the proceedings from the very beginning. He was given an opportunity to make submissions, after which the minister went silent for 7 years. So Mr. Fabiano came to the reasonable belief that the case against him had been dropped. And second, while this was going on, the minister actually made substantial progress on Mr. Fabiano's application without notifying Mr. Fabiano of what was going on behind the scenes. And this essentially denied Mr. Fabiano of several opportunities to make submissions on humanitarian and compassionate claims. So those two things together were part of the rationale why there was the abusive process finding. And yet we have nothing like this in the Plaidoiries. And we know from Blanco that the bar for abusive process on the basis of delay is very high, as high as it can be in the administrative setting. So just on that basis, the Plaidoiries have not made out the claim that the hearing was unfair. And perhaps I'll quickly go back and to the topic of inordinate delay and touch on some of the points I wanted to bring forward there as to why the court should maybe not interfere unless it is one of the clearest of cases and make up an abusive process finding on a case like this. So when the government wants there to be a limitation on the minister's ability to bring forward an application in a given time frame, that's clearly stipulated in the statute. So we have the example of the Income Tax Act, where Section 222 sub 4 gives the CRA 10 years to collect on a tax debt, after which they are barred from collecting on that debt. But absent similar language, and especially in the immigration context, we should not be so eager to have a judicial interference in this case. Now, I'm not saying that there should be no case in which courts should make abusive process findings in the immigration context, but especially given how heavily politicized the immigration sphere is, where it is at the forefront of the public eye at all times, judicial interference should be a remedy of last resort.
Well, this Mr. Jimenez-Gonzalez, this wasn't exactly judicial interference, was it? It was the RPD itself that ordered the stay. If there was judicial interference, it was by the federal court.
Yeah, so perhaps more what I was trying to get to was that we should not use these, administrative remedies like abusive process, unless we have one of the clearest of cases as laid out in the jurisprudence, for the reasons that this is such a heavily politicized process that's at the forefront of the public eye.
But I take it you don't disagree that the RPD has a responsibility to protect the integrity of its own processes.
No, we did not disagree with that point. But generally speaking, other boards have found that the interest in timely investigations generally outweighs the interest in maintaining the integrity of the justice system by holding misrepresentations accountable. So, for example, we have the case of ACREM and Canada, where the applicant experienced a 9-year delay before the minister brought forward those proceedings, but nonetheless, the court refused to find an abusive process based on that principle. So generally speaking, the administrative boards have stuck to this principle. And because we are arguing this case before the highest court of the land, and this is a precedential case. A finding of abusive process on delay alone in this case will lower that bar for the board going forward, and that's what we would like to avoid.
I don't think that's what the argument is. It's not just the delay, it's the delay plus the serious adverse consequences. The appellants have been deprived of their right to a fair hearing, and after growing up in Canada, they're now liable to be removed to a country of which they have no or little knowledge.
Thank you, Justice Evans. I see I'm out of time. May I quickly respond to your question?
You may.
Thank you. So you are correct. So it's not just delay that needs to be found. As we have argued, we do not believe that there is that hearing was unfair in this case. And as my friend will argue, we do not believe that there was personal prejudice either. So if the court, so on that basis, there should be no abuse of process finding. So it is a more wholesome or a more complete view of the law. Now, as I am out of time, I'll just conclude here, and my colleague, Ms. Freight, will speak to the topics of personal prejudice and appropriate remedy, subject to any questions that you may have for me.
Thank you very much. We'll hear now from your co-counsel, please.
Good afternoon, Justices. My name is Brianna Frape, and I will address the respondents' third and fourth submissions, beginning with the absence of significant personal prejudice experienced by the Plaidoiries, and finishing with the test for a stay. So to begin with the issue of personal prejudice, at paragraph 77 of the respondent's factum, to find an abusive process under the second branch of the Blanco test, the appellants must show that they have experienced significant personal prejudice directly caused by the delay, not the proceedings themselves. The prejudice must be significant and can include serious or profound effects on their psychological or physical integrity or stigma affecting their reputation. So there are three forms of prejudice alleged in this case by the RPD member and as iterated by my friends. The first is the loss of their lives in Canada. Second is emotional distress and anxiety they faced while facing the uncertainty about their future and the loss of their lives in Canada. And finally, facing inadmissibility and removal proceedings. So to begin with the loss of their lives in Canada, at paragraph 78 of the respondent's factum, this is clearly the outcome of the proceeding against them and not the delay. The fact that they were able to establish their lives here throughout the period that my friends argue was the delay is evidence of a lack of prejudice. This can be distinguished here from cases like Perec, where after they found out that they would likely lose their citizenship status, they didn't hear anything for 4 years, but within that period of time were unable to receive a passport after multiple applications. They could not visit ailing family members or could not spend as much time with them and had to apply to leave the country, even though they were at that time still citizens. So throughout the delay, they still faced the threat of the loss of their lives and prejudice throughout the delay. And that wasn't the case here. The only uncertainty that they faced during that time was about whether or not they would receive citizenship. But other than that, they were not denied the full right of their permanent residency status.
And isn't that prejudice? Isn't it prejudicial to not know what's happening with your citizenship application for a period of 12 years? Vavilov instructs us on the importance of citizenship to people.
Absolutely. And in Perec, it was citizenship that they lost, which triggered or that they were denied the full enjoyment of, which triggered their Charter 6 rights. But that's not the case here. Here, it was permanent resident status, not citizenship. And they were not denied any of the privileges of having that PR status.
But they didn't have an answer on their application, so they were in stasis for 12 years. Isn't that prejudicial?
It could be considered prejudicial, but not to the level that we are looking for here. That's along the lines of the second kind of prejudice, that emotional distress and anxiety as they face the uncertainty about their future, both with the loss of their lives in Canada, but also not hearing back about their citizenship application. And while that could certainly be considered evidence of harm to their psychological integrity, that stress and uncertainty, this kind of stress and anxiety is inherent in most processes, and certainly when you're applying for citizenship, that the stress of waiting, especially as we see delays, which are very prevalent but quite ordinate within the system, are to be expected. And the consequences of the proceeding against them, both with the loss of their lives in Canada and everything that they've established, and waiting to hear back about their citizenship.
Do we have any evidence in the record as to how the 12 years compares to the quote unquote normal delay that people face?
There's quite a range. I don't have numbers exactly for waiting to hear back about citizenship applications, but when we're talking about the length of the delay, as my colleague discussed, like in Perec, for instance, it was 4 years. But because there was this substantial prejudice, it could be considered an abusive process. Whereas in other cases, a longer period of time would not meet that same bar. And even then, we still need, even if there was a delay, the stress and anxiety that are inherent in the process do not go towards an abusive process. And this is the same even if they are aggravated by the delay. For example, if we look at Blanco, situation where the minister was facing, I believe it was sexual harassment allegations, and there was wide-ranging media attention that had a significant effect on his psychological and mental health, which resulted in physical health issues like high blood pressure. And that was certainly aggravated by the length of the delay. It would not have been so severe, the prejudice, had the proceeding happened more quickly. But the court held that that was the result of the media attention and not the delay. So here, the anxiety that they faced in waiting for information about their citizenship status is part of that process and that proceeding, and not necessarily directly from the delay.
Ms. Frape, I wonder if I could jump in at this point. You've stated in your factum that the standard of review is correctness, which frees our hands quite nicely to be able to decide the matter as we see fit. But I don't think it's quite fair to the RPD member to simply disregard his findings of fact. He, of course, had the benefit of seeing the witnesses, hearing their evidence. And one of the findings of fact that the RPD member made was that the delay has left the respondents with immense uncertainty about their future. And if I'm understanding your submissions correctly, I think your answer would be, well, no, it was actually the proceeding that has left them with uncertainty about their future. But my counter to that then is, isn't that uncertainty also a consequence of the delay precisely because of the impact on their ability to answer the case under 109, to make their case under 109 sub 2, linking back to your colleagues' submissions?
So we submit that the proceeding itself, this proceeding certainly could be considered the result of the loss of documents and the delay, but the prejudice that they are seeking and the uncertainty about their future is the result of the misrepresentation made by their father and that action against them, not the delay or this proceeding itself, which could more clearly be seen as caused by the delay itself and loss of documents. So this stress that they're facing, not only for waiting for their citizenship status to hear back, but also as they face these proceedings and the potential loss of the lives that they have established here in Canada, are very common in most immigration proceedings, especially where they are facing removal. That is a very serious circumstance for anyone and not an ideal situation. It is going to cause stress and anxiety. And if we were to consider that personal prejudice resulting in an abuse of process, warranting a stay, then that would certainly lower the bar significantly from the clearest of cases and remedy of last resort that has been established in Blanco. And it's clearly the cause of the process against them and not the delay itself. And to turn to the third and final example of prejudice, that is the inadmissibility and removal proceedings they are facing. This is at paragraph 81 of the respondent's factum. This is unfortunately clearly the consequence of the proceeding. They've been receiving a benefit they were not entitled to. And so the removal of that benefit through this section 109 process in the vacation proceeding is clearly the consequence of that action.
If I could just repeat the point I made earlier, we don't know if they're entitled to the status because there's not been a determination under 109.2. Or they've not had an opportunity to make representations.
We know that their status was based on their events that took place when we now know that they were in Norway. There's currently no other information to suggest that there were other procedures, but also this onus is on the appellants. And as was stated earlier by Justice Gleeson, they have not contacted the CNR for these documents. They have not tried to contact family or anyone to create any kind of reassurance that this did take place. And their removal is clearly the process of finding out that their status was based on the misrepresentation. So then because of that, the consequence of section 109 is that that status is vacated unless they can show that there were other grounds that that was based on. So we have still passed that threshold for section 109.1. There were grounds for it to be vacated. Whether or not we move to the next step is a different question.
Ms. Frape, you quite rightly emphasized the exceptional nature of a stay, particularly in the administrative context. I certainly take your point that this has to be a holistic assessment of all of the factors. But if we take a step back, should this court not be concerned about the message that would be sent if we upheld the federal court's decision, where it seems to create a very poor incentive for the minister? I mean, the minister emphasizes the public interest in ensuring the integrity of the refugee determination process, and yet for reasons that have not been shared with anyone, sat on this case for years. How can that be in the public interest?
This is certainly an important concern and definitely something that we are trying to make sure that we remember as we go forward in this proceeding, that the situation of the Kadares is not something to be brushed off. It's very unfortunate and not acceptable to the majority of Canadian society. And that interest, which is one of the most important steps in weighing whether or not there should be a stay, and I will turn there now, is one of weighing that public interest versus their moving for a stay in order to remedy the unfairness versus society's interest in having a decision on the merits is important. And there are certainly concerns about the Kadares, namely that they were innocent, is the one that my friend has stressed so much, and one that we are definitely alive to. However, Parliament has chosen not to impose a limitation period and to give the minister discretion to fulfill his statutory duties. However, they have provided other remedies in situations of such unfairness. And those other remedies are the first step, or the second step, of the Babos test, which asks whether there are other remedies that could remedy this unfairness. Because
is it any other remedy, or does it have to be an adequate remedy?
The language that I have is just any other remedy that would remedy the unfairness that they have seen. But even if it is adequate remedy, I believe that there are other very adequate and appropriate remedies for this harm that the legislature has chosen to implement rather than creating a limitation period. And
if though we find the harm under the first branch of the Blencoe test as opposed to the second branch, how can that be remedied except by a stay, because there's no way to have a fair hearing where the documents have disappeared?
absolutely. So turning to step 2 of the Babos test, that there must be no alternative remedies. This is at paragraph 87 of the respondent's factum. So what a stay will allow is for the Qataris to stay in Canada. That's the way that that remedy would remedy the unfairness. But a similar result can arise from, there are a few different ones that are listed at paragraph 90 of our factum, but in particular, an application for inland humanitarian and compassionate considerations under section 25 of the IRPA.
That's highly discretionary, of course, isn't it?
Absolutely, as is the test for a stay.
And would the applicants be entitled to stay on their removal pending the determination of their agency application?
That is definitely an interesting route and definitely one that could be a solution here. But I don't know that that's necessary, because while it's true that there is a 1-year bar after they've been deemed inadmissible to apply for agency, so that's where a stay would allow them to remain with and not face the removal proceedings, if I understand your point correctly. But that same goal can be achieved with a temporary residence permit, which the turnaround time is much quicker there, and it comes with a work permit. So that would also allow them to stay. They also have no.
What are the criteria that those permits are issued?
Sorry, do you mind repeating your question?
Yes, I'm sorry. What are the criteria under which the temporary residence and work permit are issued? And do we know if they'd be applicable here?
Yes, many of the considerations offered by my friend as reasons for why there has been evidence of personal prejudice or just facts of what makes their story so compelling is exactly relevant here, both for a temporary residence permit, which asks whether the applicants need to remain in Canada, is compelling, which if we're considering a stay to remedy the unfairness, then surely it's compelling, although I'm clearly not the one making that decision, and whether they pose any risk to Canadians and Canadian society. So,
Ms. Frape, I certainly understand your point about available options. They may not be legal remedies exactly, but available ways to remedy or forestall the prejudice on the personal side. But I'm not quite sure I heard an answer to my colleague Justice Gleason's question about a remedy for the unfairness of the proceeding before the RPD, because at this point in the argument, we would be satisfied that that proceeding is unfair. What other remedy do you say there is that could address the unfairness of that proceeding besides a stay?
So a stay in response to hearing unfairness that, and that whole branch, especially under Blencoe, which is where we're focused here, is looking at whether the proceeding is unfair, not necessarily, it doesn't ask us to create a new hearing or anything else. If we were to use a stay, that would just remove any need for them to proceed through the section 1092 route, because we have found that that's just the documents have been lost to time. They've been prejudiced by the delay in that way. And so that proceeding should be struck and they should be allowed to remain. And that same outcome, while certainly with a bit more paperwork, would be achievable with something like a agency application or the TRP. They could still stay in Canada and not face further proceedings and not lose the lives that they have created here, and et cetera, through this remedy.
But would we then just be turning a blind eye to the unfairness of the RPD hearing?
No, this is a remedy that is entitled, this is the way that Parliament has decided to remedy these situations of unfairness. This is the route that through the legislature, Justice Evans, I believe, it was Justice Norris, that this was not a legal remedy, but it is provided for in the statute by legislature. This is their response to the possibility of something like all of the documents being lost or any further steps that could have infringed on the fairness that we're seeing here.
But to pick up on this line of questioning again, counsel, and maybe draw an analogy, let's suppose you have an action in contract where there's a fundamental breach of procedural fairness, and the appellate court says, oh, don't worry, you can just go ahead and sue in tort. We won't bother remedying that fundamental breach of procedural fairness that the trial court committed. How is that, which I think we would all agree would be inappropriate? Isn't that the situation you find yourself in with respect to the first branch of Blencoe if there was a denial of procedural fairness?
The difference here is that a stay, and we get this from the language in Blencoe, is meant to be only available in the clearest of cases where the unfairness would be deeply offensive to the proceeding and society's sense of fairness. It's a very, very high bar. They're not necessarily saying, oh, there was an abusive process. In fact, the language is almost exactly, even though there is an abusive process, that does not automatically grant them a stay. That stay is a further threshold that is, again, only available in the clearest of cases and should be extremely rare given the exceptional nature of the remedy. So it is not intended to be something that is given every time there is any kind of procedural unfairness. This is a remedy available only when that very high threshold is met.
So if I understand your submission correctly, if there was unfairness, it can be corrected through these other procedures that might be available to the appellants.
Yes, exactly. And to go a little bit more into why this agency application is so available here and remedies a lot of the aspects of the abusive process doctrine that just feel like they do not take appropriate notice of the harm that has taken place here, is that one of the most important factors in an agency application is their ties to Canada. Their romantic partners are here, their friends and community, everything that my friend Mr. Fath mentioned as evidence of things that they would lose. While those are not necessarily evidence of personal prejudice or an abusive process, they are evidence of an agent's ties to Canada that would help towards an agency application. And
so
same
I think
with,
what you're saying. So I think what you're saying, Ms. Frape, is don't worry too much about this, judges. Trust us, the minister will take care of them.
essentially, yes, and that there is this process in place already to remedy this process, and that we are certainly not saying that there was no unfairness here, there was no prejudice, this is totally fine, nothing should be done, they should be removed from Canada. We are acknowledging that there is substantial harm that has occurred and that there is unfairness here, but it doesn't rise to the level of an abusive process. And there are these other remedies available in this situation.
But if we're going to balance the public interest in the integrity of the system and the harm to these individuals, I do wonder what most Canadians would think when they consider the fact that here we're dealing with people who were children at the relevant time, are now young women, totally innocent, as I think you concede, and have been allowed to lead their lives in Canada and good lives and establish deep roots. And then because of the ministerial delay, which the minister has decided not to explain anyway, they now find themselves kicked out of Canada. I don't think that many people would think that was fair or appropriate.
I agree. It is certainly a point of unfairness. It is also a point that makes them even more appropriate candidates for an agency application, as the second most important criteria is that they have faced unusual, undeserved, or disproportionate hardship, meaning from circumstances beyond their control, which is exactly what's happened here. So this is the way that Parliament has gone to remedy this. But also, when we look at the factors in favor of having a final decision on the merits, one of the major considerations is in protecting the vulnerable applicants and new Canadians. When we see evidence of both people, oh, I see that I am out of time. May I have a moment to briefly answer your question and conclude?
Please, sir.
So the government has to take a rigid and firm handling of misrepresentations to maintain the integrity of the system and to deter the use of misrepresentations in the clearest of terms, so that there is no motivation for an individual to attempt a misrepresentation in order to get that status, both for themselves or if they believe they will lose that status if their children who are innocent may still keep it. But I do notice that I'm completely out of time. So if there are no further questions, these are our submissions.
I want to thank you, Council, and thank all the Council for their helpful and thoughtful submissions. The panel will take the case under reserve before rendering judgment. No, I wasn't.
I'm happy to take over at this point, Justice Gleason.
You think I figured out how to work the mute and unmute button on Zoom by now?
So I thank everyone for their participation today. The submissions were truly wonderful, and I thank all the judges also for participating. Due to the time, we'll be closing the court now, and we'll provide an opportunity for the judges to provide comments to the mooters once we close the court up. So thank you very much, everyone. I remind everyone that the closing ceremonies will start at 6:30 in about 45 minutes, and you have the Zoom links for the closing ceremonies in both your program and in the calendar of events.
So at this point, we should now be submitting our score sheets.
Actually, we could talk about that once we close off the Zoom to the public and leave off on the YouTube recording. So I'll just wait for that to happen magically through our IT team, and then we'll give some more instructions then.